How does controversy factors way, additionally for religion under Rule 65? Under the rules of the court, under the rules of the court, is right that the people to direct the proposed amendments to the Constitution for the system of communication under Section 2 Article 17 of the United States Constitution. Without this demands special attention as the system conditionalist note of this country is that perhaps to a few scholars before the draft of the 1987 Constitution, the 1986 Constitution Convention itself, the original proponent and the main sponsor of the proposed article amendment. Revision of the Constitution characterized the system as innovative, and it indeed is followed under the 1935 and 1973 Constitution. The 19th Constitution itself, Constitution 1 through 7. Phase to Joseph the station. The right of the people to direct and propose amendments to the Constitution for the system of initiative would remain in the cold cliche of the Constitution until Congress provides for its implementation. Bluntly stated, the right of the people to direct and propose amendments to the Constitution for the system of initiative would remain in the cold cliche of the Constitution until Congress provides for its implementation stated otherwise. While the Constitution has recognized or granted the right, the people cannot exercise it if Congress, for whatever reason, does not provide for its implementation. The system of initiative on the Constitution under Section 2, Article 17, Doctrine of the Case, the right of the people to direct and propose amendments to the Constitution through the system of initiative would remain intact in the cold cliche of the Constitution until Congress provides for its implementation. So in this implementation, how it's going to be implemented or the rules. Okay, so if it's written in the Constitution, System of initiative on the Constitution under Section 2 of Article 17 of the Constitution is not self-executory. The conclusion then is inevitable that indeed the system of initiative on the Constitution under Section 2 of Article 17 of the Constitution is not self-executory. Has Congress provided for the implementation of the exercise of this right? Those who answer the question in the affirmative, like the private respondents and intervenor, Senator Rocco, point to us the RA number 6735. There is, of course, no other better way for Congress to implement the exercise of the right than through the passage of a statute or legislative act. Facts. December 6, 1996, Attorney Jesus Delfin of PIRMA, People's Initiative for Reforms, Modernizations in Action, filed a petition to amend the Constitution to lift term limit of elective officials by People's Initiative. Thereafter, Delfin petition, wherein Delfin asked the Commonwealth for an order fixing the time and dates for signature gathering all over the country, causing the necessary publication of said order in the attached petition for initiative on the 1987 Constitution in newspaper of general and local circulation, instructing municipal election registrars in all regions of the Philippines to assist petitioners and volunteers in establishing signing stations at the time on the dates designated for the purpose. He proposed to change the Constitution through People's Initiative described in Article 17, Section 2 of the 1987 Constitution. The amendments consisted of the deletion of the following provisions from the 1987 Constitution: Section 4 and 7 of the Article 6, Section 4 of the Article 7, and Section 8 of the Article 10 of the 1987 Constitution. Article 6, Section 4, it's the 6 years of term. Section 4 of the Article 7 is the 3 years. Deletion would effectively result in lifting the term limits. The Commonwealth, through its chairman, issued an order directing Delfin to cause the publication of the petition, together with the attached petition for the initiative on the 1987 Constitution, including the proposed constitutional amendments and the signature form, and the notice of hearing in 3 daily newspaper of general circulation at his own expense, not later than December 9, 1996, and setting the case for hearing December 12, 1996 at 10 o'clock a.m. December 12, 1996, hearing the Delfin petition, the following appeared. Delfin and attorney Pete Q. Quadra, representative of the People's Initiative for Reforms, Modernization and Action, or the PIRMA, intervenor oppositor Senator Raul S. Rocco, together with his 2 other lawyers and representative of or counsel for the Integrated Bar of the Philippines, IBP, Demokrasya Ipagtanggol ang Konstitusyon, DIK, Public Interest Law Center, and Laban ng Demokratikong Pilipino, or Laban. Senator Rocco on that same day filed a motion to dismiss the Delfin petition on the ground that it is not the initiatory petition properly cognizable by the conflict. Okay. December 18, 1996, the petitioners were in Senator Miriam Defensor Santiago, Alexander Padilla, and Maria Isabel Ongpin filed in special civil action for prohibition, raising the following arguments. 1. The constitutional provision on People's Initiative to amend the Constitution can only be implemented by a law to be passed by Congress. No such law has been passed. Okay. No such law has been passed. It's a right, but there's no law has been passed. Okay, so there's no supplementary law for that. So there's a right, there's an existing right. Through RA number 6735, the Initiative Referendum Act provides for three systems of initiative: initiative on the Constitution and statutes and on local legislation. It failed to provide any subtitle on initiative on the Constitution. Unlike in the other modes of initiative, which are specifically provided for in Subtitle 2 and Subtitle 3, this deliberate omission indicates that the matter of people's initiative to amend the Constitution was left to some future law. Former Senator Arturo Tolentino stressed this deficiency in the law in his privileged speech delivered before the Senate in 1994. There is not a single word in that law which can be considered as implementing the provision on constitutional initiative. Such implementing provisions have been obviously left to a separate law. Republic Act number 6735 provides for the effectivity of the law after publication in print media. This indicates that the Act covers only laws and not constitutional amendments, because the latter take effect only upon ratification and not after publication. Act. This indicates that the Act covers only laws and not constitutional amendments, because the latter take effect only upon ratification and not after publication. The public has no power to provide rules and regulations for the exercise of the right of initiative to amend the Constitution. Only Congress is authorized by the Constitution to pass the implementing law. The People's Initiative is limited to amendments to the Constitution, not to revision thereof. The People's Initiative is limited to amendments to the Constitution, not to revision thereof. So when we say amendments, it's adding something new. But what they're trying to do is to revise the Constitution. And however, the People's Initiative is only limited to amendments and not to the revision of the Constitution in which they were trying to propose. Extending or lifting of term limits constitutes a revision and is therefore outside the power of the People's Initiative. Congress has not yet appropriated funds for People's Initiative. Neither the Commonwealth nor any other government department, agency, or office has realigned funds for the purpose. December 19, 1996, this court required the respondents to comment on the petition within a non-extendable period of 10 days from notice, and issued a temporary restraining order, effective immediately and continuing until further orders. Enjoining public respondents, Commonwealth from proceeding with the Delphin petition, and private respondents Alberto and Carmen Pedrosa from conducting a signature drive for People's Initiative to amend the Constitution. The January 2, 1997, private respondents, through Attorney Quadra, filed their comment on the petition, and there were many more filing of petitions from intervenors, respondents, replies, hearings. Respondents. Issuance intended only for the internal administration of government agency or of particular persons did not have to be published. The publication, when necessary, must be in full and in office. I was not able to read the whole thing. Whether the clause, unless it is otherwise provided in Article 2 of the NCC, refers to the effectively for the people to have reasonable amount of time to learn about certain laws of the degree. I think I need to read the other verses of it. I'm running out of time. Whether RA number 6735 entitled an act providing a system for an act providing for a system of initiative and referendum and appropriating funds, therefore, was intended to include or cover initiative on amendments to the Constitution, and if so, whether the act as worded adequately covers such initiative. Whether the lifting of term limits of elected national local officials is proposed in the draft petition for initiative on the 1987 Constitution would constitute a revision of or an amendment to the Constitution held. No. Article 17, Section 2 of the 1987 Constitution, which talks about amendments through people's initiative, is not self-executory. Okay. Article 17, Section 2 of the 1987 Constitution, which talks about amendments through people's initiative, is not self-executory. Bluntly stated, the right of the people to directly propose amendments to the Constitution through the system of initiative would remain entombed in the cold niche of the Constitution until Congress provides for its implementation. Stated otherwise, while the Constitution has recognized or granted the right that people cannot exercise it if Congress, for whatever reason, does not provide for its implementation. So even though it's provided there, it was still entombed in the cold niche of the Constitution unless the Congress would provide for its implementation. Contrary to the assertion of the COMELEC, Section 2 of the Act does not suggest an initiative on the amendments of the Constitution. Moreover, the Act does not provide for the contents of a petition for initiative on the Constitution. RA number 6735 is incomplete, inadequate, or wanting in essential terms and conditions insofar as initiative on amendments to the Constitution is concerned. Its lacunae on the substantive matter are fatal and cannot be cured by empowering the COMELEC to promulgate such rules and regulations as may be necessary to carry out the purpose of the Act. So let me check what this is here. Fatal. So it's very important that if there are some words that you're not familiar with, we're going to have to check the meaning of it. Causing that, leading to failure or disaster. But if we consider the system in under section to Article 17 shall only pertain to initiative and referendum on national local laws, ordinances, and resolution, and also inadequate to cover the system of initiative, and fail to provide sufficient standard for subordinate legislation under authority and powers. 6735 notice, an act provided for system initiative and referendum and appropriating funds to reform. Unless it's like self-executory. It's not a self-executory, it's self-executory. So this is what it meant. So when we say self-executory, it can act on its own. It can be implemented on its own. The non-self-executory, therefore, would be. I'm gonna have to go back just to make sure. 6735 an incomplete, inadequate, or wanting essential term conditions in sort for initiative. The Article 17, Section 2. Article 17, Section 2 of the 1987 Constitution. Um, Amendments or revisions. So when we say self-executory, it is it can take effect without the need of legislation or further judicial action. It's self-executory. But if non-self-executory, it requires a legislative implementation before it may apply by the courts. Yeah. Valentino versus Comelec.